Programme motion to be moved formally.
I beg to move.
The question is as on the order paper. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The clerk will now proceed to read the orders of the day.
Sentencing Bill. Consideration of Lord's amendments.
Now.
I can inform the House that nothing in the Lord's amendments engages Commons financial privilege. We will begin with the Government motion to disagree with Lord's Amendment 7, with which it will be convenient to consider the other Lord's amendments and Government amendments and motions as on the selection and grouping paper. I call the Minister to move the motion. Jake Richards.
Thank you, Madam Deputy Speaker. And let me begin by putting on record the Government's welcoming of the new Shadow Justice Secretary to his job. We look forward to working with him, Madam Deputy Speaker. He is somebody of some intellectual heft, and in any event, he's in the lucky position of having extraordinarily small shoes to fill. Of course, there will be policy disagreements, as there should be, but my hope is that the new Shadow Justice Secretary treads more carefully on issues around the independence of our judiciary and respecting our legal profession, perhaps fewer vitriolic social media videos and more thoughtful analysis. And as for the member for Newark, Madam Deputy Speaker, or as he likes to call himself, the new sheriff in town, we welcome that the inevitable has now happened, confirming the fact that reform is little more than a backwater for failed Tory politicians with an ego. And Madam Deputy Speaker, just briefly, I spent 5 minutes I'll never get back, reading the memo the former Shadow Justice Secretary left lying about. It says, and I quote, "Use humour, one of your best skills. Don't be afraid to be self-effacing or have a laugh." Well, it certainly got us laughing, Madam Deputy Speaker. And his memo also has the memorable line, "Don't think. You know things to be true. Get out of the habit of saying think." I happen to think he should get into the habit of thinking a little more. The honourable member for Newark says he is joined to be part of the team. We are still unclear whether he will remain speaking on justice issues. He's not in his new place today. Over the weekend, it was said that there would be a mini reshuffle at Reform, a rather depressing game of musical chairs. But whether their justice spokesperson remains the member for Runcorn, or if the member for Newark takes over, or if the member for Ashfield has a go, or if the member for East Wiltshire or the member for Romford joins in, the story is the same, Madam Deputy Speaker, failed former Tories who cannot be trusted with our justice system, let alone our country. Now, Madam Deputy Speaker, this bill will make sure that we are never again in the position that this government inherited. Prisons at risk of running out of places entirely, leaving us with nowhere to put dangerous offenders, police without the capacity to make arrests, courts unable to hold trials, and a breakdown of law and order unlike anything we have seen in modern times. That's why this bill is vital. It does not kick the can down the road. It does not shy away from making tough decisions to keep the public safe. Instead, it will end the cycle of crisis once and for all. And it does more than this. Absolutely.
Given way. He's given a powerful speech. He will recognise this is a bill that's of huge concern to residents of my constituency of Harlow, because obviously many of those who are waiting for justice to be served, they're victims of crime who are waiting years for their the person that's caused that offence to actually see a trial. So will you agree with me? It's really important this government gets on top of this backlog and gets people in front of courts as quickly as possible.
Absolutely, and my humble friend is a fine champion of this agenda, but also, of course, for his constituents in Harlow. And as he knows, this bill does more than just fixing the crisis we inherit. It will confront reoffending, keeping our communities safe. And Madam Deputy Speaker, as my right honourable friend, the Deputy Prime Minister, set out in the very first debate on the bill in this House, it takes us back to the fundamental purpose of sentencing, punishment that works. Punishment that works for victims who deserve to see perpetrators face retribution, punishment that works for society, which wants criminals to return less dangerous, not more, and punishment that works to prevent crime. We want better citizens, not better criminals. That is what will deliver safer streets and protection from crime. This bill will restore the confidence of victims in the criminal justice system. And let me reiterate that nothing is worse for victims than prisons running out of places and crimes going without punishment, which is the situation we inherited when we came into government in the summer of 2024. Yes.
Madam Deputy Speaker, can I thank the Minister for giving way, and the Minister has outlined very clearly what the Government and the Minister in particular is trying to achieve. There are some perceptions by the general public that certainly indicated in the press and the media that they feel that maybe the Government's going to be a bit soft on those who carry out crimes. But in the rehabilitative structure, which I am very much in favour of, and which I think maybe the Minister's in favour of as well, can he outline, please, what will be done to enable those, when they leave prison, to be rehabilitated and to ensure that they don't reoffend? Because the rise in numbers of those who reoffend is incredibly worrying.
Minister.
I welcome the Right Honourable Member's intervention. I'll be setting out in the course of this speech and more generally what this Government is doing to ensure that we can increase rehabilitation and crack down on reoffending. But I would just say gently to the Honourable Gentleman, he states that there is a suggestion that this bill is somehow soft on crime. By the end of this Parliament, there will be more offenders in prison than ever before. So I completely reject that assertion. Briefly, Madam Deputy Speaker, I just want to pay tribute to the campaigners that have informed large parts of this piece of legislation and the amendments that we're discussing today. We are introducing tough restriction zones that limit the movement of offenders instead of limiting the movement of victims. These new restriction zones, which will be given to the most serious offenders on licence and can be imposed by a court, will pin any offender down to a specific location to ensure that the victims can move freely elsewhere. This was campaigned for by the founders of the Joanna Simpson Foundation, Diana Parks and Hetty Barkworth Nanton. Once again, I pay tribute to them and to all of those who have campaigned for this crucial change. And Clause 6 of this bill introduces a new judicial finding of domestic abuse in sentencing, which enables probation to identify abusers early, to track patterns of behaviour and to put safeguards in place. On this, I must pay tribute to the Liberal Democrats in particular, and in particular the Honourable Member for Eastbourne, for his tireless campaigning and willingness to work across party to deliver this. I know that all parties opposite support this crucial change. It is worth remembering more generally, Madam Deputy Speaker, that this legislation was carefully drafted as a result of an independent sentencing review led by the former Conservative Justice Secretary David Gork. I again take this opportunity. Great man, they're saying. They're voting against every single one of his proposals, Madam Deputy Speaker, but there we go. I take this opportunity to thank him again for all his work. It was a thorough, comprehensive and excellent piece of work. We are determined to ensure that the bill receives royal assent as soon as possible. There is an urgency to this process. And let me also remind the House that alongside this legislation, this Government is building prison places at a faster rate than ever before. In our first year, we opened nearly 2,500 new places, and we are on track to add 14,000 by 2031. In the next 4 years alone, we will spend £4.7 billion on prison building, but we simply cannot build our way out of the crisis we inherited from the Conservatives. The pressures on the system demands that we reform sentencing, but let me also remind the House that nothing in this bill changes sentences for prisoners convicted of the most serious, heinous crimes who are serving extended, determinate or life sentences. And of course, this bill delivers vital reforms to our probation services. We are rebuilding the service the last government decimated. We are increasing investment up to £700 million by 2028-29, a 45% increase. And we are recruiting. We hired 1,000 trainee probation officers in our first year, and we're on track for 1,300 more this year. At this point, I want to pay tribute to all the hard-working probation officers in our country. They deserve full credit for what they do, and it has been important for us to find the extra resources to put into this service to grow the numbers and the support available. Absolutely.
In government, the party opposite oversaw a disastrous privatisation of probation, which ended in a £500 million bailout by taxpayers. Our probation service plays such a critical role in the rehabilitation of offenders and keeping our communities safe. So can the Minister set out further how this bill will ensure that our probation systems are strengthened and fit for purpose?
Can the Minister perhaps restrict himself to the amendments?
Yes.
Minister.
Thank you, Madam Deputy Speaker. I welcome the intervention from my honourable friend. I'll be coming on to that issue shortly. Madam Deputy Speaker, I want to address Lord's Amendment number 7. Whilst we cannot support the amendment as drafted, we fully support the intention behind it, to promote transparency and improve the experience of victims. We agree that robust processes are required to ensure the accuracy of transcripts, but placing a statutory duty on the judiciary to approve the release of all Crown Court transcripts could significantly increase workload and undermine efforts to drive down the Crown Court backlog. However, Madam Deputy Speaker, I'm delighted to say that we have tabled a government amendment that will expand the provision of Crown Court sentencing remarks to all victims who request them free of charge. This new clause puts victims firmly at the centre of the process, ensuring that every victim can request and receive relevant sentencing remarks for free. This clause delivers a major step forward for transparency, enabling victims to digest sentencing remarks outside of the pressures of a courtroom setting and free of charge. The details on timeframes and processes will be set out in due course, but I can confirm our intention to the House that this will specify that transcripts will be provided within 14 days of a request being made. This timeframe will support applications made under the unduly lenient sentencing scheme, and I can also assure the House that we are considering the opposition's amendments to the Victims and Courts Bill, which would extend this deadline to 56 days, extremely carefully. I'm grateful to members of this House for their engagement on this issue. This change represents a profound step forward for victims and for transparency in our justice. I know that the honourable members for Richmond, Warrington North and Lowestoft have been campaigning on this issue for some time. They deserve great credit, in particular the member for Richmond, if I may. And so for the first time, every victim whose case is heard in the Crown Court will have this important right of access free of charge. I turn now to Lord's Amendment 1. And again, I must begin by thanking the Honourable Member for Bexhill and Battle, the Shadow Justice Minister, and the parents of Lenny Scott, an ex-prison officer murdered by a former inmate in a horrendous revenge attack. This amendment meets their call for a small but important reform to sentencing around whole-life orders. We recognise the unique and dangerous job that police, prison and probation officers do. They perform a distinctive role with routine contact with dangerous offenders. We want to ensure, Madam Deputy Speaker, that the exceptional seriousness of murders that are motivated by their important work, which strike at the heart of the rule of law, are expressly recognised in the sentencing framework for murder.
Will the Minister give way?
Yes, of course.
I thank the Minister for giving way. A comment often made to me and my colleagues when I was policing, as soon as I left the police station in full uniform, I was a sitting target every single day. Does the Minister agree that the mandatory whole-life sentence is proposed for those who murder police officers, prison officers and probation officers sends a clear and unequivocal message that they will be met with the harshest and most serious penalties on offer to the court?
Absolutely, and I thank my honourable friend for his service and his contribution and his support for this amendment. As I said when I had the great privilege of meeting Lenny's parents last week with the Shadow Justice Minister and Lord Timpson in the other place, it's not just about the technical mischief that this amendment solves, because thankfully these cases are few and far between. It is about sending a signal to the brilliant prison officers and probation officers that the work they do is respected by people in this place, in the country at large, and that we can make this small change as part of this legislation, I hope, goes some way to doing that. And indeed, I've met prison officers since we've announced this change who have intimated their gratitude to Lenny Scott's parents in particular and to this place for hopefully making this change. And that's very welcome indeed. I want now to move, if I may, Madam Deputy Speaker, to the amendments 2 to 5, which relate to Sentencing Council. Through these, we have sought to help clarify what is expected from the Lord Chancellor and the Lady Chief Justice when considering any approval requests from the Sentencing Council for its business plans and sentencing guidelines. Broadly speaking, these amendments do three things. First, if the Lord Chancellor decided not to approve a business plan, Amendment 2 requires them to notify the Council. It also requires them to lay a document before Parliament as soon as practicable, stating the reasons for that decision. Amendments 3 and 4 make similar provisions under different guises. Secondly, we want to make it clear that there is a very high bar that must be met for any guidelines to be rejected. Amendments 4 and 5 therefore provide that guidelines can only be rejected when this is necessary to maintain public confidence in the justice system. Finally, we have set out on the face of the bill that any approval requests from the Council are to be considered as soon as practicable. Taken together, Madam Deputy Speaker, these amendments represent a significant step by the Government to ensure that these approval processes are surrounded by clear safeguards, transparency and accountability. Yes, absolutely.
While the Lords have endeavoured to amend the bill in a number of areas, the provisions of Part 4 allowing foreign national offenders to be deported at any time within their sentence is very important to Northern Ireland. Given Article 2 of the Windsor Framework, that assessment has been made of the risk that these offenders will actually not be removed, leaving Northern Ireland with a two-tier system in which foreign criminals benefit from additional EU-derived human rights protections rather than being sent home. Would you commit to meet with myself and a number of my colleagues on this important issue to Northern Ireland?
This issue was raised, I think, at second reading and at report stage by one of the honourable member's colleagues. The legal advice that we have received simply states that there is no discrepancy in Northern Ireland. I'm very happy to have a conversation with you and any other colleagues on that. It's clearly only right that these provisions apply also to Northern Ireland as well. Madam Deputy Speaker, this government is committed to greater transparency on prison and probation capacity and holding current and future governments to account. We have demonstrated this by publishing the first annual statement on prison capacity in December 2024. The 2025 edition will follow shortly. This amendment delivers on that promise by making it a statutory requirement to lay a statement before Parliament each year. Legislating on this duty ensures transparency in the long term and delivers on the government's commitment to do so. Never again we will be in a situation that this government inherited, where the previous government had overlooked prison capacity for 14 years, leading to the crisis that we had to deal with. The government has also accepted Amendment 12, which removes the clause in the bill that would have introduced the power to publish the names and photographs of those subject to an unpaid work requirement. The purpose of this clause was to increase the visibility of community payback and ensure the public can clearly see justice being delivered. We remain committed to ensuring that local communities can see the benefits of community payback in their area. However, we have listened carefully to the issues raised in both houses concerning this measure, and perhaps more importantly, the concerns raised by our brilliant probation and prison staff on the ground. And after careful consideration, we do not consider it appropriate to proceed any further. We are confident that current delivery of unpaid work, bolstered by wider provisions in this bill, means that unpaid work will continue to be tough and visible without the addition of this specific measure. Finally, Madam Deputy Speaker, we are very pleased to have made further progress on the issue of IPP sentences. We want to do everything we can to support those who are still serving these sentences to progress to the end of their sentence, but we are not willing to undermine public protection. The amendments made in this bill strike that careful balance. The Victims and Prisoners Act 2024 made significant changes to the IPP licence period. The qualifying period for referral to the parole board for consideration of licence termination was reduced. It went from 10 years after first release to 3 years for those serving the IPP sentence and 2 years for those serving the DPP sentence who were convicted when they were under 18. It has now been over a year since the first of these measures came into force. 1,700 people had their licence terminated automatically on the 1st of November 2024, and a further 600 became eligible for referral to the parole board on the 1st of February of last year. We have now gone further by providing those serving the IPP sentence with an earlier opportunity for licence termination and an additional opportunity for those serving IPP and DPP sentence thereafter. Those serving an IPP sentence will be considered for licence termination 2 years after release rather than the current 3 years. This provides suitable time for support and rehabilitation in the community, whilst ensuring our communities are best protected from harm.
Would the Minister give way?
Yes, absolutely.
I thank him for giving way, and I welcome the amendments relating to IPP sentences. It's a matter of concern to many across the House. Can the Minister assure the House that changes to IPP licence termination will continue to provide for community rehabilitation whilst protecting communities from harm? And can the Minister also commit to continuing to work to resolve the remaining challenges around these sentences?
Absolutely. And my honourable friend, as a member of the Justice Select Committee, always brings thoughtful contribution on justice issues, but in particular IPP. There is that balance that has to be struck between protecting public safety, but also ensuring that there is rehabilitation. The government thinks that this legislation has gone some way to doing that, but there is always room for further review and assessment as we go forward. And I know that Lord Timpson, who's leading on this piece of work for the government, will continue to engage, certainly with the Justice Select Committee on this issue. Madam Deputy Speaker, I'm very grateful for the improvements that have been made to this bill during its passage in the House of Lords, and I hope, in particular with the undertakings I've given on the provision of sentencing transcripts, I hope that all parties will be able to support the government's amendments in lieu of Amendment 7. These represent a major step forward for transparency and for victims, and I beg to move these amendments.
The question is that this House disagrees with the Lords in their Amendment 7. I call Shadow Minister Dr Kieran Mullan.
Thank you, Madam Deputy Speaker. And as we've heard today, the House is considering amendments made in the other place to the sentencing bill. There is no doubt that our justice system is facing significant challenges. I've always acknowledged this, and during recent debates on a wide range of issues from sentencing to prison capacity to probation to jury trials, there's been cross-party acknowledgement that for decades, across a number of governments of different colours, there hasn't been sufficient investment or political priority given to our justice system. But that should not and must not serve as an excuse for this government to bring forward changes to our justice system that damage it, failed to actually address the challenges before us, and slipped through the net changes that elements of the Ministry of Justice have always wanted to do and are simply using the excuse of the current challenges to finally pull off. But that is what we are seeing, both in relation to the proposals on jury trials and even more clearly to the clear detriment of victims in this sentencing bill. I welcome elements of this bill. Some of the examples we'll go on to discuss, and the Minister mentioned, for example, the restriction zones, the domestic abuse markers, but these are overwhelmingly outweighed by the fact that the heart of this bill is a catastrophic blow to the victim's search for justice, as it will let out thousands of rapists, paedophiles and seriously violent offenders out of prison earlier. The Minister mentioned in his opening remarks the Independent Sentencing Review, and I remind members of this House that the Independent Sentencing Review gave absolutely no consideration whatsoever to what victims and the public would think of the proposals related to sentencing. And actually that report is an insult to victims and their families, and many of them have told me directly. At least during the common stages of this bill, every other party joined the Conservatives in voting against these dangerous proposals, including the Liberal Democrats, and in fact a number of Labour MPs bravely abstained. It should be a matter of deep shame for the Liberal Democrat Party that they have since joined Labour in voting to let rapists and paedophiles and seriously violent offenders out of prison earlier, especially as they so clearly articulated why this was wrong before. A complete betrayal of serious victims of crime and their families. This is likely my final opportunity to say to this House and MPs opposite that I'm confident they will come to regret these elements of the bill and will find it difficult to explain themselves to victims when they see perpetrators of crimes like rape, child sex offences and child grooming leave prison sometimes only after having served a third of their sentence because of their support for these measures. I will do whatever I can to ensure those victims know who made those choices when there were so many other alternatives available to them. But as I do have to accept that this government majority, with the help of the Liberal Democrats, has ended that campaign for now, we should consider the amendments of this bill before the House today. And as I know the public greatly value constructive cross-party working, I want to begin with an important area where we were able to secure government support in relation to Law's Amendment 1. This amendment ensures that where a police officer, prison officer or probation officer, including a former officer, is murdered because of their service, a whole life order will be the starting point for sentencing. This change originated from the opposition, and I'm grateful that the government accepted the principle following my meetings and campaigning with Paula and Neil Scott, whose son Lenny, a former prison officer, was murdered because he refused a bribe from an inmate. Parliament has long been clear that those putting themselves in danger directly by confronting and standing up to the most dangerous people in our society should have the greatest possible protection of our law available to them. That is a whole life order. We had previously legislated to that effect through the mandatory whole life order for those that murder police and prison officers in the course of their duties. The case of Lenny Scott highlighted a gap in the law, though. Lenny was brutally murdered years after his service as a prison officer in revenge for handing in a phone he'd found in a prison cell search. Imagine, years later, having moved into a new phase of his life, enjoying work, the gym, time with his children and the rest of his family, being shot in a car park late at night simply for doing his job. Lenny's mum told me how she knew something was wrong when Lenny didn't come home that evening. She even went out in the middle of the night to look for him, only to have the police arrive at her door at 1 a.m. with the devastating news. It's been a true privilege for me to work with her and Lenny's dad, Neil. And I want to extend my sincere thanks to Lord Timpson and the other place and the Minister for taking the time to meet with them both and agree to work with them further to see what else we might do to improve protections for our prison officers. I'm sure the Minister will agree it was clear from the meeting what decent, moral people they are, which explains the sort of person Lenny was. I'm also very grateful to Lord Timpson for bringing fresh thinking to this area by including probation officers in the measure. They also must work closely with dangerous, violent offenders and sometimes stand up to them to protect the public. They face the same dangers and so should get the same protections. Whilst our wider focus must always be on preventing crime and protecting the public, it's right that clear gaps in the law are addressed when they arise. The opposition therefore supports this amendment in lieu of her own, and I know Lenny's parents and all his family and friends have been delighted to see its progress in the House. In my time working with victims on campaigns, I've learnt the pitfalls of naming a law after an individual case. There are always others that might warrant the remembrance of their own experiences in the naming of a law, but for Lenny's family personally, they would have every right to call this measure Lenny's Law. Yep. Next, Madam Deputy Speaker, I'd like to consider amendments that are attempting to deliver reform in an area much needed, but are simply insufficient. Lord's Amendments 2, 3, 4 and 5 all concern themselves with the relationship between the Lord Chancellor and the Sentencing Council. Between them, they provide guidelines for specific scenarios where the Lord Chancellor may not approve the Sentencing Council's business plan, conditions for withdrawing consent for the Sentencing Council's issuing of sentencing guidelines, conditions of withholding the consent to a request from the Sentencing Council to issue allocation guidelines if it's necessary to do so in order to maintain public confidence in the criminal justice system. We saw in the debacle over two-tier sentencing just how far the Sentencing Council has strayed, and these measures will not fundamentally correct that. The official opposition has made it clear in the past, and I will restate it again, that it is our firm policy position that we would abolish the Sentencing Council and restore power back to elected ministers directly accountable to the public and give Parliament a role itself. The functions of the Sentencing Council in delivering consistency through sentencing are well recognised, and it is not our intention to do away with those functions, which will be restored to the Lord Chancellor's office, but we believe it is for the Justice Secretary to be responsible for our sentencing guidelines, not a group of unelected individuals with no direct accountability to the public and limited accountability of any kind. Consultation with the public is not the same as accountability to the public, and we are clear Parliament should have the power to act as well. Therefore, Madam Deputy Speaker, whilst the amendments are not a point of contention in the bill's progress, we will not divide the House on them, I raise them to point out that they would not be part of a bill introduced by a Conservative government, as we would abolish the Sentencing Council entirely and fully restore accountability. Next, Madam Deputy Speaker, I want to draw the House's attention to Lord's Amendment 7 on court transcripts of sentencing remarks proposed by the opposition and supported in the other place. Lord's Amendment 7 would require sentencing remarks delivered in the Crown Court to be made available within 14 days of a request, free of charge, subject to judicial approval and existing reporting restrictions, and published online. As I mentioned, this was a Conservative amendment. Let's start with something we can all surely agree on. Sentencing remarks matter. They are how judges explain the seriousness of the offence, the harm done to victims, and the reasons for the sentence imposed. For victims and offenders, a sentence being passed in a Crown Court will be a moment of extreme seriousness in their lives. I think we can surely agree that it shouldn't be that unless you can afford to pay, you'd have to simply rely on your memory or on scribbled notes by those in the court on your behalf, and not have a word-for-word record of this event is a good example of how for decades our justice system has been doing things that no one can really justify from any party, and these things must be changed. For victims and families, access to these remarks is often central to understanding the outcome of a case and to having confidence that justice has been done. It will also be crucial for them to give consideration to making an application to the unduly lenient sentence scheme, as the Minister mentioned, which the Government continues officially to insist should remain at 28 days, though I do take on board the Minister's remarks that they're giving consideration to the 56-day time limit. I would just say I know what's incredibly important to the families is as well as a wider overall limit, is that those directly affected by the most serious crimes get a more extended period than just simply 56 days, equivalent to the offender's ability to have a unlimited appeal in exceptional circumstances. So I do hope the Minister takes that on board. The last Conservative government initiated the piloting of access to the remarks for victims of murder, rape and other sexual offences. I'm not aware of anything from this pilot that would make for an argument against the measures we've proposed. Lord's Amendment 7 addresses that problem directly by placing a clear duty on the Court on the face of the bill to provide sentencing remarks within 14 days free of charge and publish them. The Minister said it would be all remarks. That's not what the amendment says. It says remarks on request. And this is actually short of where we should be in the end, which is to aim for all court transcripts, more generally of proceedings, to be made available. But we've been sought to be modest with the aim of garnering wider support. We have to remember we have a system of open justice with very limited exceptions. In the vast majority of criminal cases, any member of the public can walk into a court and hear each and every word that's said. I acknowledge that ministers have since indicated a willingness to move in the direction of greater access, and that is welcome, but their proposals fall short. Under the approach now proposed by the Government, key details, including the timetable for provision, the scope of any exceptions and the safeguards that will apply, will be set out in regulations, and the remarks would only be available to the request of victims rather than other individuals. For something as fundamental to victims and society's understanding of justice as sentencing remarks, the opposition does not believe that is good enough. If the Government truly agrees that victims should receive sentencing remarks free of charge within 14 days, then there should be no difficulty in keeping that guarantee in the bill itself. It does not allow for the publication of remarks for others to be able to see them either, and I'm also not clear if a victim receives the remarks under the Government's proposals if they'd be allowed to forward and share them and publish them themselves. And why does wider transparency matter as well as being a measure for victims? I would point members to the historic injustice of the appalling grooming gangs offences. It's clear that the hard work done to revisit historical examples of these offences and ensure the public are fully aware of their full horror of what happened and continues to happen to these girls and boys has made a difference to the public and Parliament's understanding of these offences. This is what transparency does. It drives accountability, and it should not simply rest with the victims to secure that. The judiciary accept that in principle through our open courts and through select broadcasting of sentencing high-profile cases that transparency is vital, and this agenda must continue to be driven forward, and the government's proposals fall far too short. At a time when public confidence in the justice system is under strain, transparency and accountability are not optional extras, they are essential. Lord's Amendment 7 delivers a clear, practical improvement for victims and others by guaranteeing timely, free access to sentencing remarks in primary legislation, and the opposition will vote to keep it, and I urge the House does the same. I don't intend to hold the House further to ensure others with particular interests in other amendments have the opportunity to speak. I've made clear we welcome some of the provisions of this bill, but I've also made clear that whatever positive it brings, this bill is enormously damaging to one of the core purposes of our justice system, ensuring victims of serious crime and their families are able to secure true justice. It's a matter of personal regret for me that I was not able to persuade members opposite of the damage this bill will do to that, and it will now fall onto the shoulders of victims and families in future months and years to speak up when their perpetrators walk out of jail early, and even more concerningly, the victims who are stalked, abused, raped or violently attacked by criminals when they should have been in prison. It will fall on them to speak out and get these measures reversed. Those of us on these benches will be there to help them raise their voices. At least, I hope by then, some of the members on the benches opposite will do the same.
Thank you, Madam Deputy Speaker. This bill delivers the long-term, joined-up, sustainable reform our criminal justice system desperately needs. I want to comment today on Amendments 1 to 7 alongside Amendment 14, amendments I believe will strengthen this bill. Madam Deputy Speaker, we inherited a system on the brink. Prisons close to running out of places, courts paralysed by backlogs, police forced to operate with one hand tied behind their back, trust broken and fear raised, a breakdown of law and order that left communities like mine in Portsmouth paying the price. In Portsmouth and across the country, the justice system is struggling under the weight of an unprecedented backlog. Crown courts in England and Wales now have between 77 and 78,000 outstanding cases waiting to be heard, with tens of thousands open for a year or more, and some defendants waiting for up to 4 years before trial dates are even available. These delays, Madam Deputy Speaker, mean victims in my city and beyond are denied timely justice, eroding confidence in our courts. The sentencing bill and wider reforms are a crucial step towards tackling these backlogs, speeding up justice and ensuring offences are addressed without further delay. The Conservative Party talks tough on crime, but their record tells a very different story. They increased sentencing lengths without building the capacity to support them, and in 14 years they added just 500 prison places. When the system finally broke, they released tens of thousands of offenders early, largely, Madam Deputy Speaker, in secret. 10,000. In secret, shattering public confidence in justice. This government is working hard to fix their mess. We believe in prisons, Madam Deputy Speaker. Many offenders must go there, and some, Madam Deputy Speaker, for a very long time. Many offenders must go there. We have already opened 2,500 places, and we're on track for 14,000 by 2031, the biggest expansion since Victorian times. But we also have to be honest about the challenge. We cannot build our way out of a Tory prison crisis alone. We owe it to the British public to reduce crime and to reduce victims. That is why this bill reforms sentencing, so punishments can actually cut crime and rehabilitation can help reduce crime and reduce victims. That includes tough, credible and visible punishments in our community. Offenders will be closely monitored through tagging, restrictions on where they can go and strict conditions that curb their freedom. Courts will be able to impose no-go zone banning offenders from entering specific areas such as town centres, retail zones, building sites or industrial estates where they have previously offended. These, Madam Deputy Speaker, are not soft options. They are enforceable restrictions backed by modern technology and real consequences if breached. This approach is vital for crime that devastates working people, and particularly I'd like to mention, Madam Deputy Speaker, the horrendous life-changing crime that is tool theft. In Portsmouth and across the country, tradespeople have told me the story time and time again. When tools are stolen, it's not just property they lose, it's income, cancelled jobs, damage to reputation, and families pushed into financial stress overnight. And in some cases, Madam Deputy Speaker, it has led to the taking of our tradespeople's lives. It is because of this I have campaigned relentlessly on this issue, working closely with tradespeople, industry bodies, police, insurers and retailers, and together we made the case that tool theft must be treated as serious and repeated crime. Because of that work, this bill and the amendments delivers real change for these victims. Repeat tool offenders will now face tougher sentences in court and also in our communities.
Does she accept the vast majority of the result of this bill will only have to serve a third of their sentence instead of half?
I believe that we are clearing up the mess left by the Tories, where people are still waiting for their day in court. It is not okay to commit a crime and not even be able to sentence for 4 or 5 years. If you'd like to intervene again, I'll sit down.
The facts are, those tool theft victims that she's talking about, will any single one of them agree that those people should only serve a third of their sentence?
I think they'll be serving more than was under the Conservatives when they didn't care about tradespeople or construction crime. Repeat tool theft offenders will now face tougher sentencings because of a Labour government, including tagging on release, strict movement restrictions, robust unpaid work and no-go areas, stopping them returning to the places where they targeted working people. This is about disrupting criminal behaviour, protecting livelihoods and showing that Labour is the only party that stands squarely with those who work hard and play by the rules.
Thank her personally for the work that she's done on tackling the huge issue of tool theft, which has had a huge impact on tradespeople in my constituency of Harlow. So can I personally thank her for that work? And does she agree with me that, as she said previously, that it's not just about the person themselves, but it's also about their family, their livelihood, and it has a huge impact on their mental health to be a victim of such crime. So I thank her for her work.
I thank my Honourable Friend for his kind words and the work he has also done in Harlow. And I repeat, my knowledge, there was not a government before us that even cared about tradespeople. Alongside this, we are investing, Madam Deputy Speaker, up to £700 million more in community punishment and increasing probation funding by 45%. That means better supervision, faster enforcement and a system that is credible to both offenders and to the public, and again looks to reduce repeated crimes for victims. In addition, I particularly welcome a number of government amendments which further strengthen this bill. As a daughter of a retired police officer, and I notice my honourable friend from Portsmouth South is in the room, and his dad was a retired probation officer, I have family and friends still serving in the forces and as prison officers. I welcome Amendments 1 and 14, which broaden whole life orders. Murder, Madam Deputy Speaker, is the most heinous crime a person commits, and these amendments ensure that those who murder police, prison or probation officers, including where the crime is motivated by their current or former duties, face the full force of the law. These crimes strike at the very heart of the rule of law, and it is right that sentencing reflects that. I also welcome Amendments 2, 3, 4 and 5, which strengthens transparency and accountability around the Sentencing Council. These amendments set a very high bar for rejecting sentencing guidance, ensuring Parliament is informed where decisions are taken, and help maintain public confidence in the justice system. Crucially, they sit alongside the reforms that reflect legislation I fought for in my tool theft bill to ensure sentencing properly takes account of the full circumstances and impact on victims. That principle is vital. Justice must never lose sight of the harm that is done to victims and communities when crimes are committed. Amendment 6, Madam Deputy Speaker, is another important step. By placing a statutory duty on the Secretary of State to publish an annual report on prison capacity, this government is ending the culture of secrecy we inherited and ensuring proper accountability to Parliament and to the public. Madam Deputy Speaker, I strongly welcome the government's changes in lieu of the Lord's Amendment 7. Which will ensure victims can access transcript of sentencing remarks free of charge. This is meaningful improvement for victims, an important move towards a more transparent and humane justice system, and another step in the right direction of putting victims at the heart of our justice system. Madam Deputy Speaker, this bill ends the chaos we inherited. It restores confidence in justice, and it delivers punishment that works for communities like Portsmouth. now and into the future. I am proud to have worked hard on developing this bill, and I am proud to support it.
Yeah. I call Liberal Democrat spokesperson Jessica Brown-Fuller.
Thank you, Madam Deputy Speaker. And I would like to thank members across both chambers for their contributions to this and their continued work, particularly the Prisons Minister for engaging collaboratively with Liberal Democrats in the other place and making concessions both in the legislation and at the dispatch box. We are pleased to see the Government amendment to the Lords Amendment 7 today, which would introduce the provision of free transcripts of sentencing remarks for victims. As a long-standing campaign of my honourable friend, the member for Richmond Park, for the provision of all court transcripts, it is a great first step to see victims gaining access to this improved level of transparency and accountability.
Will my honourable friend give way?
I'll happily give way to my honourable friend.
I'm very grateful to her for giving way. I just want to take this opportunity to say my own personal thanks to the Minister, to everybody involved in bringing the legislation to this stage, and also pay tribute once again to my constituent Juliana Talizzi, who came to see me when she was charged £7,000 for the transcript of the trial that saw her rapist sent to prison. This is a huge step forward for victims of all kinds, and I am really, really pleased to see this in our debate today. And I just want to put on record my huge thanks to everyone for that.
I thank my honourable friend for reminding us that at the heart of this piece of legislation that's coming forward in the sentencing bill is victims and their ability to understand what's come in sentencing remarks. Because given that so much happens in a court trial, whether reliving past trauma or confronting a perpetrator, for many, listening to proceedings can feel like a foreign language. For others who choose not to attend the sentencing hearing, they have no knowledge of what was said. That is why having consistent free access to transcripts is so vital, as it provides an opportunity to process the events of court proceedings afterwards or to read them for the first time. For many, this can give closure and an opportunity to move on, but it is also the route for appealing a sentence if they believe it to have been unduly lenient. Providing victims with court transcripts free of charge would markedly improve experiences for victims and survivors, but I do have some questions regarding the amendment that the Government have brought forward. So my questions to the Minister are, could he provide some clarity as to the application of the term victim is in the definition used by the Victims Code, and whether in the case that a victim is unable to personally request sentencing remarks, such as victims without capacity or victims that are children, that immediate families of victims are included within the provision?
Will the member give way?
Happily give way to my honourable member.
Because I can't ask the Minister himself, I might ask you whether you think we also need clarity on whether deceased victims' family members might also have a right.
I thank the honourable member for his point, and the Victims Code lays out that a victim, if they are deceased, that immediate family, being parents or siblings, would be included, which is why I asked that question of the Minister. Also, subsection 3C allows the Secretary of State to provide exceptions to the requirement to supply a transcript of sentencing remarks. What sort of exceptions does the Government anticipate? And as per subsection 3D, what sort of information might be omitted from a transcript? And if the Secretary of State doesn't plan to use sweeping powers to accept or omit, why have such provisions in the amendment been included? The previous Government ran a very limited pilot of free court transcripts. Will this Government publish a detailed publication of the review of that pilot? We believe that this could and should go much further, as per the campaign by my honourable friend for Richmond and Baroness Brinton in the other place. And we have tabled an amendment to the Victims and Courts Bill, which would mean all transcripts were provided free of charge, including judicial summaries and bail decisions. The Chief Lady Justice recently spoke to the Justice Select Committee about a pilot with HMTCS, the use for AI for transcripts, especially in the asylum and immigration courts, and she described it as a great success. So I'd be keen to understand if the Government will work with the Liberal Democrats to progress this work, because we do appreciate the growing cross-party support on this issue and the work of all in the other place to achieve this really important first step today. We also welcome the Government committing to a statutory annual report into the state of prison capacity and, importantly, the probation service. This is an important mechanism for oversight, which will improve long-term assessments of the health of our justice system. And we were very happy to see the Government accept our amendment to remove Clause 35 from the bill, which did nothing to address the crisis in our justice system and was totally at odds with the Rehabilitation of Offenders Act. We also welcome the amendments tabled by the Government to strengthen protections in relation to the Lord Chancellor's approval of sentencing guidelines. We have been supportive of many of the provisions in the bill aimed at addressing some of the key failings in our crumbling justice system. Our courts, prisons and probation services are all at breaking point and without urgent intervention are at risk of failing completely. The bill offered an opportunity to ease some of those pressures our system faces, where currently the needs of victims, offenders and the system more widely are too often ignored. We do also need to ensure that our prison system is one of rehabilitation, one that ends the cycle of reoffending and reduces those long-term pressures. All of the Liberal Democrat work on this bill has been in that vein in order to get the legislation into a better place to achieve those aims. So to briefly conclude, Madam Deputy Speaker, we realise the mess our justice system finds itself in. We've always aimed to work collaboratively and productively cross-party to ensure that we can begin to turn the tide on this, and we will continue to do so. We need a sustainable solution to this crisis, which includes cutting reoffending and tackling the court backlog to reduce the number of people in prison on remand, and properly resourcing our probation service, which will no doubt feel the impact of this legislation most acutely. The bill contains a number of proposals that Lib Dems have campaigned for as part of the wider package of reform, but it still could go much further to ensure that it's fit for purpose to protect victims and safeguard our justice system for the future. Thank you.
Jameson.
Thank you, Madam Deputy Speaker. I'm pleased that this bill will deliver some long-term and sustainable reform to our criminal justice system and make sure that we never again end up in the position where dangerous offenders aren't being locked up, the police don't have capacity to make arrests and courts are not able to hold trials. It was frankly a breakdown in law and order like nothing we have seen in modern times, because the last government increased sentence lengths without reckoning with the consequences of doing that, adding just 500 places in their time in office, and that was a dereliction of duty beyond comprehension, and I think that's something that must not be forgotten in the context of this bill. Our prisons were brought to the point of crisis, and frankly they only survived till the general election in 24 because they, on the quiet, largely released 10,000 offenders, completely undermining public confidence in our justice system. And why? Well, it's true, and the opposition Shadow Justice Minister shaking his head. I was working in the prison service, I know what went down, I know exactly what happened. And that's why this bill is so important, because whilst it was born out of necessity, it is bringing forward the kind of reform which will be absolutely transformational and which, frankly, governments of all colours should maybe have done in years past. That doesn't mean we're not being tough on crime, in fact quite the opposite, because as the Minister's laid out today, there's going to be more people in prison at the end of this Parliament than there has ever been in the past. But as has been previously been outlined in this debate today, anyone that thinks you can simply build your way out of this crisis is not living in the real world and is not serious about public policy. So it is welcome that we're deporting more national offenders and bearing down on the court backlog to reduce remand prisoners. All of this is necessary but not sufficient, which is why this bill is very, very welcome today. I want to speak specifically about Amendments 1 and 14 around broadening whole life orders. When I was a prison officer, I found it personally incredibly frustrating how little acknowledgement was given, frankly, by wider society about the serious level of assaults and injuries that staff often had to suffer. And this is something I'll be taking up with the Minister maybe on another time, because I know it's not directly about this amendment. But I do think it's important that there is that public recognition about how dangerous the job can be for probation officers as well. And I want to pay tribute to Lenny Scott's family, who have worked tirelessly to advocate for this change. It is very welcome, and I hope that every member of Parliament from across the House will support that amendments, and those amendments today, sending the clear message that this House backs our police, probation and prison staff, particularly with the dangers that they face, and send a clear message that we support them this day and indeed every day. Madam Deputy Speaker, as I said at the start of this bill, it may have been born out of necessity and, frankly, emergency at the start of this government, but I am proud that it is a Labour government that is bringing forward the reform that our justice system has long needed, and I am proud to support the government amendments today.
Leave the House, Minister.
With leave of the House, Madam Deputy Speaker, today is a pivotal day, subject to agreement from this House in due course in the other place. This bill would have completed all its stages and will shortly become law. And Madam Deputy Speaker, I want to take this opportunity to thank, first of all, my predecessor, my honourable friend, the member for Scunthorpe. Although I've been the minister who's taken this piece of legislation through the House, his painstaking work in developing the policy has been fundamental, and he deserves great credit. I want to thank my honourable friend, the member for Portsmouth North, for every single opportunity she quite rightly raises her campaign for clamping down on tool theft, and she's taken that opportunity again. She is a fine champion on this issue and for her constituents. And I want to thank my honourable friend, the member for Doncaster Central. She brings huge experience to this. To these issues, and we are taking measures to offer further protection for prison staff, but I'm very happy to speak with her about what more the government can do. Very briefly, Madam Deputy Speaker, just some of the issues that have been raised. On the Sentencing Council, we've aired this debate before, but the Conservative position, which was developed by the now former Shadow Justice Secretary, the member for Newark, it is a team effort. I'm not sure about that. It is an example of real constitutional vandalism. It has never been the case that the judiciary this would threaten the independence of the judiciary. What these amendments do and what this proposal does that's set out in this legislation is ensure there is a democratic lock around sentencing, ensures there is a role for this place, but that the Sentencing Council remains independent, and that is absolutely the right thing to do. On transcripts, I welcome that there is a degree of a consensus on this. The Conservative position on this amendment at the back end of last week and then early this week seems to have changed a few times. This strikes the right balance. If anyone could seek a free transcript of sentencing remarks, we might be in a position where our court staff, who have a big job at getting a grip of the backlog, are spending all their time issuing transcripts. This strikes the right balance. On the specific issues that the honourable member, the Liberal Democrat spokesperson, has raised, of course we have to look into it when victims are children, whether they are deceased, whether there is a lack of capacity. It may be that the Victims Code does that already for us, but absolutely, but we absolutely have to get it right, Madam Deputy Speaker, and we will ensure we do so as this policy is developed. She mentioned her concerns about exceptions and omissions and asked me to ponder on examples when those exceptions could be engaged. Well, of course, when there are issues of national security or public safety, it may be relevant, but I can say at the dispatch box that one would hope that that would be extremely exceptional circumstances. But it is important that those provisions are in there. We believe that this provision will allow more openness. It's ambitious but also realistic considering where the technology is at the moment and also the pressures on our court system. But do we want to go further when we can? Absolutely. We believe in the fundamental principle of transparency and openness in our justice system, and where we can, we will. And Madam Deputy Speaker, yes, absolutely.
Here for his opening speech. I was chairing the Justice Committee, but I don't think that matters because I ought to agree with him on these amendments. They strengthen the bill considerably. They do bring more openness and they do bring more transparency, and we welcome, I think, all of the recommendations here, whether they be in relation to the Sentencing Council or the Prison Capacity Report, or indeed the transcript new version of Lord's Amendment 7, and indeed IPP prisoners. They're all welcome improvements on this bill. They need to go further in some areas, we think, particularly in relation to IPP prisoners, but this is a good step along the way.
Well, I always welcome the intervention from the Chair of the Justice Select Committee. As I said, following an intervention from my right honourable friend, the member for Colchester, the work on IPPs is an ongoing process, led by Lord Timpson in the other place, but an ongoing process, and I know that he will always be happy to engage with honourable friends in the Select Committee. Madam Deputy Speaker, then, I can conclude my remarks by stating very firmly that this bill will solve the mess that this government inherited and begin to make sure that our prison system is fit for the future. I want to once again place on record my thanks to all honourable and right honourable members who've engaged with this bill throughout its passage. That expertise strengthens it in many important respects, and I beg to move, Madam Deputy Speaker.
The question is that this House disagrees with the Lords in their Amendment 7. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. Is as on the order paper. As many as are of that opinion say aye.
Aye.
Of the contrary, no.
No.
Tellers for the ayes, Jade Botterill, Stephen Morgan. Tellers for the noes, Harriet Cross, Gregory Stafford. Order, order.
The ayes to the right, 319. The noes to the left, 127.
The ayes to the right were 319. The noes to the left were 127. So the ayes have it. The ayes have it. Unlock. With the leave of the House, I shall put a single question on Government Amendments A and B in lieu of Lord's Amendment 7. I call the Minister to move Amendments A and B in lieu of the Lord's Amendment 7 formally.
To move.
The question is that Government Amendments A and B in lieu of Lord's Amendment 7 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. With leave of the House, I call the Minister to move that this House agrees with the Lords in their amendments 1 to 6 and 8 to 15. The question is that this House agrees with the Lords in their amendments 1 to 6 and 8 to 15. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Point of order, Sally Jameson.
Thank you, Madam Deputy Speaker. I wish to apologise because I inadvertently made an error. At the start of my speech on the sentencing bill, I forgot to declare that I remain a member of the Prison Officers Association following my time in the prison service, and I hope that the record can be corrected.
I thank the honourable member for her point of order. Her comments are now on the record, and the record is corrected.